Hello, I'm Rob Hassett with InternetLegal.com, and this is the first of a series of videos I'm putting together about law for entrepreneurs. This one's on trademark law for entrepreneurs. All the videos are going to be 6 to 10 minutes long, and this one's going to be about 8 minutes long. And I'm going to give you an outline of what I'm going to be telling you. Today you're going to learn the difference between trademarks and service marks and why it matters. I'm going to talk about the legal strength of marks, what it takes to acquire rights in a mark, test for infringement, and priority rights for the first user. Alright, what is the difference between a trademark and a service mark? A trademark relates to goods like Heath bars or Snickers for a candy bar. Service marks relate to services like Kroger for grocery store services. Some marks are used both ways. Like McDonald's can be used as a trademark when you say it's for McDonald's hamburger. When you refer to the quick service restaurant as McDonald's, that's being used as a service mark. Now, why does it matter? Well, it matters because the way you use your marks, you're required to use your marks in certain ways to create or keep your rights in a trademark, and in different ways for a service mark. Now, a service mark you're going to use it right anyway, because what you do is use it in advertising, displays, signage, websites, promotional materials, flyers. But that doesn't work. Most of that won't work for a trademark. For a trademark, you need to put it on the packaging or on the goods themselves. And the next topic is the strength of marks. There's 5 categories of strength of marks. The weakest, and they run from the weakest to the strongest. The weakest is what we call a generic mark, such as shredded wheat, that just states what it is, what the goods and services are. No one can own rights in a generic mark. Second weakest are descriptive marks. They're descriptive of some aspect of the goods or services, or misdescriptive, like big tire for big tire company that has a lot of big tire stores, or little tire, which is misdescriptive, would be treated the same way. You can't own rights in a descriptive mark or misdescriptive mark until you've created what's called secondary meaning, which means that you've used the mark and advertised it and promoted it enough that the buying public associates your mark not with the description of the goods or services, but with your business. Other 3 types of categories are all marks that can be obtained immediately. I'll tell you how they're obtained in a few seconds, but the other categories are suggestive, which is a mark that requires imagination to connect the word mark logically to the goods or services, like Greyhound for buses. Arbitrary, which when you use a word as a mark that's not logically connected to the goods or services, like Apple for computers. And finally, the 5th category are made-up marks. Made-up words like Google and Kodak. The next topic is, how do you gain rights in a mark? There's 2 ways you can gain rights in a mark. Acquire rights in a mark by using the mark for the particular goods and services you want to use it for in a particular area. That gives you rights in that area, like Atlanta or Seattle. You can also gain rights by applying to register it in the United States Patent and Trademark Office, provided you do everything you need to do to get the registration. Your rights would be as of the date you applied. And what's good about that is it gives you rights for the whole United States. Now, what if I use the mark in Atlanta before you use it in Seattle, and then I apply to register it? Well, then I would get the whole U.S. except for what you already had. Well, using it in before I applied. What if you apply and you use it in the U.S. second? I can get your registration blocked or revoked. So that's why we do these extensive searches, to make sure nobody else has priority rights over us because we all want a mark that we can register. That brings me to my final topic today, which is what constitutes infringement of a mark. Let's say I own a mark. Infringement occurs if you use the same or similar mark in a way that is reasonably likely to make people think that what you're selling them is my product or service. And I understand that normally that means that for infringement, normally that means that you're using the mark for related goods or services. What I mean by that is if I own the mark Varsity for restaurants, it's not infringement for you to use that mark for cars, shoes, baseball bats, etc. But there is a concept known as dilution that applies if a mark is famous. And under federal law, that means that it is a household name, like Coca-Cola. Because of the dilution doctrine, you may not use Coca-Cola for any product or service whatsoever. Well, that's it for this video. Thank you for watching. If you'd like to get in touch with me, you can reach me at this number, 678-514-1557, or my email. You can use my email, rob@internetlegal.com.